on earth are you going to know that you're parking more than 18 inches? What time of day or night was this? 4 in the morning. You can tell. All right, I'm going to find no probable cause.
The justice system is pretty beat up in our country, but some honest-to-God judges are still holding the line. One of these judges is David Fleischer, whose blunt responses have made us all proud.
Mr. Hardy, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. Shh. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge.
Okay.
On November 22nd, 2024, the officer observed the defendant's vehicle parked more than 18 inches from a curb on a public roadway in the right lane of a two-way road in Harris County, Texas. While the officer ran the motor vehicle, the passenger side door opened, a black female exited, and the female approached the patrol vehicle. The officer made contact with the female and observed a strong odor of marijuana emanating from the female. The officer made contact with the defendant, the driver of the vehicle, and observed a strong odor of marijuana and had the defendant exit the motor vehicle. One red package with fruity pebbles on the front containing a green leafy substance in the back seat, and 2 clear plastic baggies containing green leafy substance under the front right passenger seat. The officer also observed 1 burnt cigar behind the front passenger seat and 1 small chunk of loose green leafy substance in between the driver's seat and the door. The green leafy substance was identified based on training experience, and the weight was 54 grams or 1.9 ounces.
Fully aware of the officer's dishonesty, the judge questioned the probable cause for the initial search and sharply confronted the attorney.
Parking while black now? Come on.
Your Honor, there's no time listed. It just says the officer was on patrol around the 3518 block of Arbor Glen Drive when he observed the vehicle parked more than 18 inches from the curb.
And so he goes up to the car because of that?
No, Your Honor. A female passenger side exited the passenger side and approached their vehicle, and he observed a marijuana from the
because
female.
he comes up to them. Right? Stop. Are you losing?
The officer wrote as he ran the vehicle, presumed the license plate.
Right, he pulls him over.
They were already parked on the side of the road 18 inches from the curb, and he came, I guess, parked behind, and he was running the vehicle, and then the passenger side door opened, a black female exited and approached his vehicle, the patrol vehicle, and he observed an odor of marijuana on the female, and then he made contact with the driver, where he observed marijuana odor in the vehicle. So the female approached the patrol vehicle.
The officer had clearly racially profiled the individual and inadvertently revealed the real reason for the arrest. Watch as the attorney begins to stumble over his words and the judge swiftly dismisses the case.
Show me in the penal code that code. What is the penal code for that?
Regarding the 18 inches from the curb, sir, is that the issue of what we're talking about?
Yeah, because they come to him because he comes to them. Right, they're just parked. He comes to them. It's got to be a transportation code, not penal code, you know?
And Your Honor, regarding the timeline of events, it does appear that when they were parked that distance away, which could be arguably further, I don't know what it looked like at that time, but the female passenger is the one who exited first, and that was before officers ever made contact with them. So I don't know if you were thinking that the officers approached them first, but I just wanted to clarify that she approached first.
What time of day or night was this?
It was at 4 in the morning.
And Your Honor, I found
4 in the morning.
4:30 a.m.
And you can delineate at 4 in the morning that parking 18 inches from a curb.
And I found the regulation, the statute in the transportation code where it says you have to park within 18 inches.
It's at 4 in the morning. You can tell.
Your Honor, the officer was.
Yes, I don't think so. All right, I'm going to find no probable cause.
Yes,
All right, guys, be careful, right? You know, they're always out there.
Mr. Fleischer is surely one of the only good and empathetic judges in the country as of now, and just a few minutes later, he helps save another individual from these corrupt cops.
No one sees him driving.
He was just parked across the street.
No, no. What? Really?
Next is a case involving an individual charged with driving on a suspended license. However, the officers never actually saw him driving. They based the charge solely on his own statement. Here's what the police report said about the incident.
On December 2nd, 2024, officers were dispatched to a minor accident on Sam Houston Parkway. Upon arrival, the officer met with both parties of the accident as well as a witness. The witness advised that there were minor disturbances on the scene in which a knife was brandished by the defendant, who was parked across the street from the accident. The officer identified the defendant and discovered he had a mandatory suspension on his driver's license for a second DWI. And the defendant advised that he had still been driving for work. He had personal business despite having personal knowledge of the suspension. The defendant stated he was driving from San Antonio and was only waiting for his coworker who was involved in the accident.
Does he have an open DWI right now?
Does not appear so, Your Honor. It appears that the last DWI he had was in 2019 out of Bexar County.
Bear.
Bear County, yes, Your Honor.
Okay. Mr. Patlan,
Yes, sir.
I want you to understand one thing. I'm going to find that there's... So, wait a second. Someone saw him driving, or did the officer see him driving? Because I didn't...
He admitted that he had been driving for work. And he admitted to having personal knowledge of suspension as well.
Did anyone see him driving?
No, Your Honor, there's only the
Do we
statement.
know even when he was driving?
There was an accident, that's what dispatch involved, and then
Okay, so, all right, okay, so,
there was an accident, and then officers arrived, and then they made contact with the defendant.
got it. So all this was in response to an accident that he was allegedly involved in.
Yes.
Got it. All right. So I am going to find probable cause, Mr. Patlan.
Once again, the judge quickly read between the lines and recognized the corruption behind the officer's action. However, before proceeding, he issued a warning and a stern threat to the individual.
No, don't. You have the right to remain silent. Exercise. I've got about a bunch of DAs here. Anything you say, they're going to use it against you. But let me make something abundantly clear to you. I'm going to have you sign with me today an affidavit. This is a promise that you're making to me that you're not going to drive. I don't care what is going on in your life. When we mean no driving, we mean no driving. I don't care if there's a burning building and you have to save 50 kids. Do not drive. If you do, I can have a contempt hearing facing up to 6 months in jail and a $500 fine every time you drive. Do you understand? I don't care what your excuse is. You cannot justify at all any reason. If you want to drive, go get a license, get liability insurance, and then we can talk. But until that point, I will even do this. This is the number to the DPS Driver's License Division. If you call them, they can tell you exactly what you need to do to get your license back.
Classes now, sir.
There may be, an SR22. You may have to do all these other things. What you need to do is call them and they can advise you, but don't drive.
Now, coming back to the case, as the judge asked for more details, he realized that once again there was no probable cause for the arrest. The case deserved a similar treatment to the earlier one.
I do have to make a correction. After reading the full DIMS, the defendant was parked across from the accident. It was his coworker that was involved in the accident. He was parked across, Your Honor. And I do apologize. After reading the complete DIMS, the officer wrote that the defendant was parked across the street from the accident, and he made a statement that he was waiting on his coworker who was in the accident.
No one sees him driving.
He was just parked across the street.
No, no. What? Really?
He made the statements that
I get it.
He was in the vehicle and he made the statements.
I took a shower today. No. I mean, you just make a statement. I mean, no, there's no proof.
To having knowledge of the suspension, and he was in the vehicle parked across the street.
But no one sees him driving?
He did make a statement.
No.
And just like that, the judge dismissed the case, making it clear that corrupt officers wouldn't be getting a free pass. Now, while this honest judge did a great job, here's an incident where a corrupt cop was sentenced to jail.
Defendant Aaron York deemed guilty beyond a reasonable doubt of the offense of manslaughter. Assess his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days.
Aaron Dean was on duty. He responded to a residence late at night and fatally shot a woman inside her bedroom. The jury did not take long to reach a verdict.
Y'all did fabulous when we did the guilt-innocence verdict, okay? Same rules apply. I don't know what this verdict is. Can't have any emotions, all right? Let's bring him in. Mr. Dean. Verdict reads, we the jury, having found the defendant Aaron York Dean guilty beyond a reasonable doubt of the offense of manslaughter, assess his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days. They do not assess a fine. And it is signed by the presiding juror. You may be seated. Thank you very much.
As expected, the killer officer didn't have many signs of worry on his face and didn't show any remorse whatsoever. Finally, the judge went over to announce his sentencing.
Juror number 1, is this your verdict?
Yes, Your Honor.
Juror number 3, is this your verdict?
Yes, Your Honor.
Juror number 4, is this your verdict?
Yes, Your Honor.
Juror number 6, is this your verdict?
Yes, Your Honor.
Juror number 9, is this your verdict? Juror number 37, is this your verdict?
Yes, Your Honor.
Juror number 38, is this your verdict?
Yes, Your Honor.
Your verdict will be received and filed. Thank you very much. Mr. Gill, Mr. Brissett, is there any legal reason why sentence should not be pronounced?
No legal reason.
Mr. Dean, it's the jury having found you guilty of the offense of manslaughter and assessed this punishment. It's the order of the court you be remanded to the custody of the sheriff, be delivered to the director of the Texas Department of Criminal Justice to serve your sentence as required by law. You will receive credit for all the time that you have served in custody on this case from the date of your original arrest up until today, which would be the date of sentence. If you are indigent and cannot afford a lawyer, I would conduct an indigency hearing to determine if you are indigent. And if you are indigent, I would appoint a lawyer to represent you on appeal and provide you a record of this appeal of this trial at no cost. Is there an allocution?
Yes.
You may be seated. Thank you very much.
Receiving just 11 years for taking an innocent life is far too lenient, and once again, this officer benefited from the so-called special treatment often reserved for law enforcement. And now we're back with Judge Fleischer, who saves a guy from an officer's lies and a false charge.
None of that? I mean, who's writing the reports? Mickey Mouse? You know? I mean, really? No, I haven't heard anything.
A man identified as Gonzalez was charged with evading arrest and resisting arrest. Now, things could have gone terribly wrong for him, but luckily, he had a great judge on his side.
On March 22nd, 2025, at around 7 p.m., officers were dispatched to 1855 Work Road in Houston, Harris County, Texas, in regards to a criminal mischief in progress. Upon arrival, the officers observed the defendant at a location matching the description on the call slip. The officer gave verbal commands for the defendant to lay on the ground and put his hands behind his back. The defendant ignored commands and ran away from the officers. A foot pursuit was initiated, and the officers continued to yell verbal commands for the defendant to stop running. The officers were able to detain the defendant approximately 100 meters away. The defendant then actively resisted, and the officers had to dry stun him. The defendant was using both hands to push off officers in order to avoid detainment. The defendant grabbed the officer's ballistic vest and attempted to push the other officer. The defendant attempted to push officers multiple times, and the defendant struggled on the ground for approximately 3 minutes before he was detained.
Once again, the judge realized that no actual crime had been committed, and this arrest was only one part of the officer's escalatory tactic. Therefore, he didn't take much time to drop the charges.
What was he doing wrong? All you said he matched a call slip. So?
Yes, for a criminal mischief in progress, Your Honor.
That's completely conclusory. What is the alleged mischief? What did he do wrong? Who did he do wrong to?
And I don't have that information.
Then none of that? I mean, who's writing the reports? Mickey Mouse? You know? I mean, really? I haven't heard anything. I'm going to find no probable cause. Mr. Gonzalez, be careful, man.
Okay.
When you get into a pissing match with people who have the power of arrest, who's going to win?
I'm gonna be more careful. I promise. It's not gonna happen anymore. I promise. I got my family. I wanna,
Okay?
Thank you.
Got it.
God bless you.
Now, that is what you call an actual slap in the officer's face who has been writing these bull records. But this certainly wasn't the last time this respected judge stood up for citizens' rights.
It was in the glove box. Stop it. Are you losing?
Yes, sir. That's all we have.
Okay, I'm going to find no probable cause.
Miss Jackson was charged with marijuana possession, but as she appeared before the judge, the prosecutor began reading the officer's report, and Mr. Fleischer quickly spotted a major inconsistency.
Ms. Jackson, you now stand charged with possession of marijuana. You're facing up to 6 months in jail and/or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Yes, Judge. On September 26, 2024, officers conducted a traffic stop on a vehicle bearing an expired agent tag. Officers made contact with the occupants of the vehicle. Defendant Cephas was arrested for a DWLI, and defendant Jackson had active warrants out of Webster PD. Officers conducted an inventory of the vehicle and located 2 small black bags containing a green leafy substance on the passenger side where defendant Jackson was sitting, and a backpack containing a firearm in the trunk. The substance was identified as marijuana based on training and experience. The weight was 4 grams or 0.141 ounces. The defendants denied ownership of both. The defendants were identified with Texas driver's license.
As expected, the police report was full of flaws and clearly manipulated against Jackson. That's when the judge tore into the prosecutor and dismissed the bogus case within minutes.
Okay, I have so many questions.
Yes, Judge.
So first off, you said defendants,
Yes,
plural.
there are 2 defendants, Your Honor.
Right. So the driver,
Yes, Your Honor.
okay, and then the weed was found where?
Under the passenger seat where defendant Jackson was sitting.
In what?
In a 2 small black bags.
How do you attribute the bags to her?
Your Honor, they were just located on the side of the vehicle where she was sitting.
So could be his. Just puts it there. I don't know.
Yes, Your Honor, but the affirmative link would be in the proximity of where she was sitting as well.
Have anything else that identifies the bag as hers? The guy is, the person's a guy, right?
Yes, Your Honor.
Okay, so is there a lipstick? Is there anything else that would identify the bag as hers?
No, Your Honor. All we have is that it was located on the passenger side glove box, just those 2 small black bags.
Glove box.
Yes, Your Honor.
Absolutely not. No,
It was in the glove box.
stop it. Are you losing?
Yes, Your Honor. That's all we have.
Okay, I'm gonna find no probable cause. Be careful with the company you keep. When you hang with dogs, you get fleas, Miss Jackson. You know this. Come on, please. Just take a seat.
It is really incredible how this judge serves with such honesty and calmly de-escalates the matter. But this judge was different. He grew visibly angry with the sheriff for blatantly ignoring his command.
Prosecutor Pearl has charged you with 15 counts of criminal conduct. And I'll go through it. Count 1, corrupt business influence is a level 5 felony. It would indicate that pursuant to Indiana Code 35-44-1.1-2-1, that on or about a period of time from November the 9th, 2018 and August the 16th, 2023 in Clark County, state of Indiana, you did knowingly or intentionally through a pattern of racketeering activity acquire or maintain either directly or indirectly an interest in or control of property or enterprise contrary to the form of the statute in such case made and provided. Count 2, theft as a level 5 felony. You then personally sold said Hellcat for $83,000, $83,716. Count 4, theft is a level 6 felony under Indiana Code 35-43-4-2A.
Numerous charges were also brought against Jamie Knoll's daughter, Casey, and his wife, Misty. It is truly remarkable to see how the sheriff was able to engage in such corruption and yet maintained his position in the agency for such a long time.
On or about August the 16th, 2023, in Clark County, state of Indiana, you did knowingly or intentionally alter, damage, or remove any record, document, or thing with the intent to prevent it from being used, produced as evidence in any official proceeding or investigation, that being you factory reset your phone upon the arrival of the Indiana State Police on your property. You, in your capacity as Clark County Sheriff, public servant, did knowingly or intentionally assign to Rodney Walker, an employee under your supervision, duties that were not related to the operation of the governmental agency that you serve, that being sheriff, assigned robbery duties on your personal property, rental properties, father-in-law's property, pole barn, property of Utica Fire Department. Count 11. And count 15. Official misconduct is a level 6 felony. It would indicate that between November the 9th, 2018 and December the 31st, 2022 in Clark County, state of Indiana, you, a public servant, that being sheriff of Clark County, knowingly or intentionally committed an offense in the performance of your official duties, that being goes to employment as sheriff of Clark County relating to Brent Fisher. Mr. Knoll, the first 3 counts are level 5 felonies, which have a range of imprisonment from 1 year to 6 years, with the advisory sentence being 3 years and up to a $10,000 fine. Counts 4 through 15 are all level 6 felonies, which have a range of imprisonment of no time in jail, treated as a misdemeanor, to 2.5 years at the Indiana Department of Corrections, with the advisory sentence being 1 year and up to a $10,000 fine. Do you understand what you've been charged with?
Yes, Your Honor.
Do you understand the potential penalties?
Yes, Your Honor.
The next question is, usually you intend to hire a lawyer, but you obviously have counsel seated with you. I need to tell you, you have a right to a speedy public trial by jury in this county. You have the right to face all witnesses against you, severe question and cross-examine these witnesses.
Jamie sat through the proceedings with a complete lack of guilt as the judge systematically read out the 15 counts against him during the hearings. The tension was high in the courtroom as the state attorney made a strong case for his detention without bond. Despite the gravity of the charges, the judge decided to grant bail, but little did he know that this would turn out to be a serious mistake.
His passport to you by noon tomorrow, and then you will surrender it to the court by 4 p.m. next Monday, because it's my understanding the court here is closed tomorrow.
Yes, sir.
He will surrender all firearms except one shotgun of his choice to Indiana State Police. Being from the country, or as Mr. Wilder said, Washington County, I keep my shotgun with double aught near me, along with my .45. But I think one shotgun for personal protection is appropriate for him to maintain. He will not leave the state of Indiana without permission of the court, and they'll post $75,000 in cash. Mr. Knoll, you wanted him released without posting any bond, but it's a unique case, and if you don't like my decision, I'm happy for you to appeal it. It won't be the first time you've appealed me, and the Court of Appeals told you I was right, so I'm happy for you to accept that challenge if you so please. I'm not going to have you report in.
After delivering the announcements, the judge made one thing unmistakably clear, leaving no room for confusion or misunderstanding.
Keep one shotgun only. Try to deceive me, you will not like the consequences.
Yes,
Understand?
Yes, Your Honor.
Okay.
And then, Judge, the issue of return of all other items seized, we can just take them in another hearing?
Well, it wasn't set for today, so
No.
yeah, we'll deal with that at another time. I assume now that everything's going to be unsealed, there'll be a lot of new things brought before the court that
Yes, Your Honor.
we'll address in due time.
Thank you, Judge.
Anything else?
No, Your Honor.
Nothing else from us, Judge. Thank you.
All right, we'll be off record. Thank you all.
Although Jamie was first granted bail, however, his freedom was quite short-lived. When he violated the judge's order, police raided his residence in March and found a stash of hidden weapons. When the judge was called back for another court appearance, he was clearly outraged and did not hold back this time, delivering an uncompromising reprimand.
I told Mr. Knoll, don't do anything stupid. Do not try to deceive me, defy me. You will not like the consequences. Today is that day. You are not the law. You don't interpret the law. You don't enforce the law. You're not above the law. I find that you are in contempt of this court, Take him into custody. No, that's enough. I'll find you guys in contempt for disrupting the proceedings, and you'll be there right there with him.
Ironically, Jamie Knowles' appearance in A&E's 60 Days In, a series that exposes the inner workings of law enforcement, ended up on the wrong side of the court. During sentencing, the judge made an intentional point of mentioning his feature in the series, highlighting the sharp fall from grace of the former sheriff.
Now, what is an appropriate sanction? The question is, I can sentence him up to 180 days without a trial, or I can sentence him to a day, or I can release him. You know what I think the answer is? 60 days in. That's what I think the answer is today. Now, Mr. Wilder.
Yes, Your Honor.
Or Mr. Boyles, I apologize, Mr. Boyles, your lead. Before he is released, I'll take your suggestion. I want an independent individual to scour that household to determine that there's no further weapons. I find it, Mr. Ertle's original argument that he was trying to make that I sustained, an officer of the law, every time I go into court, I hear, I didn't know it was there. I didn't know it was there. It really did. You've heard that a million times. You've heard it a million times, and yet you still take them into custody, would be my guess. Every officer in the world has heard, I didn't know it was there. It's my friends. I'm not buying it. It was your burden. It's your responsibility. And today, the court will enforce that. Take it away.
When this victim told the judge what the cops thought about her, she completely flipped off.
They told me that the judge don't make the rules here. That was the quote that they...
Who told you that? Oh, hold on. Mr. Flanagan, call Mr. Farmer right now. Call him right now.
Police officers often overestimate their authority, making reckless decisions that eventually cost them their jobs. While some manage to dodge accountability for a while, the courtroom is where the truth catches up. A young man named Jalen Lee, who was on probation, was called in for a hearing. He had already paid over $30,000 in fines and was making an effort to turn his life around. The judge was even impressed by his progress.
You did choices.
Yes, ma'am.
Through eBay, and then you've completed 8 of the 10 gamblers counseling. Well, let's see.
Nope.
That she's saying 2 different things. How many gamblers counseling is left?
I finished all 10.
Oh, you did?
Yes, ma'am.
Okay. So let's do this. How long do you think it'll take for you to complete or pay the 510?
I started a new job within 2 days. So my first paycheck within basically 2 weeks, I'll be able to pay it.
You gonna give us all your money? I don't know how much the check is. Don't give me the saying it's all your money. I mean,
it's literally been all my money. So.
Right. But I can give you a couple of months if you want a couple of extra months. I can give you a couple of months.
I mean, yeah, that will work better. Absolutely. Whichever one works.
All right. I mean, 'cause today is just the halfway point. So you're not technically scheduled to be discharged from probation. The 12 months, you're not scheduled until May 2nd. I could give you a date in late January if that'll be better for you.
It seems like the probation officers just never wanted to let a good guy get out of the criminal system and were desperately setting him up for failure.
If he completes it and pays the money, you could send an email to Mr. Flanagan, and I can discharge him without you coming.
Okay, that sounds great.
All right, so I'll put it on the docket for January let's put it on the docket for February 3rd, that first Monday in February. I'll put it on the docket for February 3rd. And then that way we could confirm with Ms. Collins that you've completed those classes or the counseling, and then you can pay the $510. If you've done so, counsel, you can just submit an email and I can confirm it with the probation, and then I can discharge him without appearance. So we'll put it on the docket for a discharge.
Judge Lanise showed kindness and appreciation for Jalen's effort. However, what he learned next left him completely shocked.
Ms. Bryant, so up until this point, I'm still expected to check in regularly and do the normal probation process until January.
What do you mean by that? Tell me what do you do? What's the normal probation process?
Well, because originally they were telling me that once I came into this review, I could have the potential to be discharged from the probation since I had did all the classes and everything like that.
So here,
right now,
I'm gonna interrupt you, Mr. Lee. You're on a non-reporting probation anyway. So if they've had you reporting monthly, you didn't have to do that.
I said that originally, but they told me that the judge don't make the rules here. That was the quote that they.
Who told you that? Oh, hold on. Mr. Flanagan, call Mr. Farmer right now. Call him right now. Woo.
Yes.
It's going to be a great day. Call him right now. I need you to tell us who told you that. Call him right now. Matter of fact, you can call Mr. Wade too. Call them right now. Because I'm about to. Yes. I like you, Mr. Lee. I like you. You didn't even mean to tell on them, but you did.
The probation officer clearly undermined the judge's authority, and Judge Lanise got excited as she knew the officer was about to get into trouble. No matter what, you just don't insult a judge like this.
Because if I ever hear somebody say that again, I'm going to hold them in contempt. Yeah, but we gonna do this right now. Oh, I'm so excited. This turned out to be a great Tuesday. But you did not have to report, Mr. Lee. You were not supposed to be reporting on a monthly basis. And we getting ready to nip that in the bud right now. I'm so excited for my future and yours.
Not only this, but the judge also apologized on behalf of the corrupt probation officers.
Drug screen.
They've been having me do a drug screen. I was like, I don't even smoke, or my case had nothing to do with anything, related, but I've been doing the drug screen every month.
Mr. Lee, let me apologize on behalf of the court. And I'm thankful that Ms. Bryson no longer works here because she might have got fired today.
Understood.
So you do not have to test. My order specifically says no urinalysis was ordered. And so what I'm going to do is refund you any money that you have paid for your drug screens. So where were you testing?
The judge took a firm stance, ensuring that Jalen received every possible compensation for his efforts to turn his life around. At the same time, she made sure the officers, especially Farmer, were held accountable for their mistakes and thoroughly taken to task. While these cops were taken to the cleaners, this next officer was immediately humbled for his action.
Correct. So the dog decided to send him to secondary. Correct.
This Border Patrol agent used to stop people for fun and took the law for granted. However, one of them decided to file a lawsuit against him, and here's how the attorney took him to the cleaners.
When you're at the Border Patrol checkpoint, your duties are to enforce immigration laws and look for terrorists and look for weapons of mass destruction and assist in detecting narcotics. Is that correct?
Yes, sir.
And when you do this, of course, you're following a procedure manual that tells you what to do?
Following policy, sir.
Written policy?
Yes, sir.
You have a copy of the written policy?
No, I do not, sir.
Have you ever seen a copy of that written policy?
That states our authority to conduct immigration checks, or for the checkpoint itself, sir?
For that checkpoint.
No, I have not, sir.
Are you aware of any written guidelines or policies or procedures on how to run that checkpoint?
I am aware that they're out there, sir.
You're aware that they're out there?
The attorney really breaks the spirit of the corrupt cop, as he has nowhere to hide and fails to even maintain eye contact. Watch how he keeps on delivering sucker punches.
Let me get this straight. You're testifying right now that you are aware that there are written guidelines and procedures for this checkpoint?
Can you state that question again, sir?
Is it your testimony here and now that there are written guidelines and procedures for this checkpoint?
To my knowledge, yes, sir.
Have you seen them?
No, I have not, sir.
But to your knowledge, they exist.
Yes, sir.
The attorney keeps digging himself into a big hole, unable to cite any law that authorizes the checkpoint. To make matters worse, the attorney reveals he has a voice recording that completely undermines the officer's claim.
Do you recall on June 1st of this year giving a telephonic statement to Mr. Victor?
I do not recall the exact date, but yes, I do recall a telephonic interview, sir.
Do you recall you were in a room with Mr. Katz?
Yes, sir.
I believe there was another attorney in the room who was a representative of the Border Patrol Union?
Yes, sir.
And you were on the telephone to Mr. Victor?
Yes, sir.
And you're aware that that tape recording was being recorded?
Yes, sir.
And were you trying to tell the truth at that time?
Yes, sir.
Do you remember being asked during that statement if you were aware of any written guidelines, policies, and procedures for this checkpoint?
Do I remember that specific question, sir?
Yes, sir.
No, sir.
Do you remember saying that you were not aware of any written guidelines, policies, or procedures?
No, sir.
Would it help to refresh your memory if you heard a tape playing of your voice?
Yes, sir.
Your Honor, if I may.
If you want to use that one, it's fine.
It starts right at the beginning of that.
This one needs to.
Playing the audio wasn't as straightforward as expected. The defense attorney quickly jumped in with objections, trying to block it from being admitted.
This is your voice, and if you remember being asked this question and given this answer.
And Your Honor, the state's going to object at this point. Was this noticed as part of your trial exhibit and disclosure?
Actually, Judge, this doesn't need to be noticed because it's impeachment, which is exactly how we're using it right now.
Your Honor, the same standard would apply to both parties, the state would expect. And everything that be given in notice to both parties.
Judge, the law's well settled in Arizona. If the defense had to give impeachment to the state of the state's witnesses before the state's witnesses testified, it wouldn't be much of impeachment, would it? We're simply disclosing the audio tape of the interview that the state's witness, where the state's counsel was present throughout the entire interview.
Your Honor,
I have no understanding what possibly could be the objection to this.
Your Honor, may I have a moment?
You may.
Your Honor, Mr. Victor is quite correct under Rule 613B. The state withdraws its objection.
The judge, determined to uncover the truth, overruled the objection without hesitation. It was finally time for the agent to get a taste of his own medicine.
Just ask this question. Do you have any written policies, procedures, or guidelines on how the operation of that particular checkpoint is to be conducted?
No, to my knowledge, no. I'm there to determine citizenship, sir. If somebody's traveling through there, say, some sort of checkpoint, they're U.S. citizens, they're free to go. If they're not U.S. citizens, they say they are not.
Agent Gomez, did you recognize that as your voice?
Yes, sir.
Were you asked the question if there were any policies, procedures, or written policies, procedures, or guidelines for that checkpoint?
Yes, sir.
And what is your answer that you were not aware of any?
Yes, sir.
Thank you.
This was rock bottom for the officer, being publicly proven wrong in court. The Border Patrol agent's stops were deemed illegal, and he was about to get schooled all over again.
To have your testimony correct that when people pull up and you ask them if you're a U.S. citizen and whether they answer yes or no, then they're on their way?
Yes, sir.
So if someone pulls up and you say, are you a U.S. citizen, and they say no, they're on their way?
No, sir.
Well, which is it? You just said if they say yes or no, they're on their way. But tonight you've said, I asked the question a different way. If they said no and you said they're not on their way, which one is it?
Usually if somebody says no, they already have their immigration documents with them. They present that to me and they're on their way.
And do I have your testimony correct that if you are unable to determine citizenship at the checkpoint, do you usually try to get them to go to secondary?
Yes, sir.
Not all the time?
No, sir.
So sometimes you cannot determine citizenship at the primary, but you just let them go.
No, sir.
And now I'm confused again.
The Border Patrol agent was making no sense whatsoever, and he seemed to be caught up in his own lies. The attorney kept exposing his hypocrisy for everyone to see, and what he revealed next will leave you stunned.
I originally asked if you are unable to determine citizenship at the primary checkpoint, that you usually try to get them to secondary.
Yes, sir.
I did not say always try to get them to secondary. Do you understand my question?
Yes, sir.
Usually means sometimes not, doesn't it?
Yes, sir.
So is it fair to say that sometimes, if you are unable to determine citizenship at the primary checkpoint, that you let them go anyway?
No, sir.
I don't understand again. If someone comes up and you cannot determine citizenship, you say you usually try to get them to secondary. Is that correct?
Yes, sir.
Usually means not always. Is that correct?
Yes, sir.
Like, I usually wear a suit to court, but not always. Do you understand that?
Yes, sir.
So there are some times that people come up and you are unable to determine citizenship, but you just let them go on their way. Is that correct?
No, sir.
What do you do with them?
I try to establish the citizenship there.
And suppose you can't.
And they go to secondary, sir.
So if you are unable to determine citizenship, they always go to secondary.
Yes, sir.
Not usually, but always now.
Yes, sir.
The officer had messed up so badly that there was no coming back from it. Imagine doing your job without even understanding the law or the procedures that govern it.
Mr. Anderson was sent to secondary inspection because of the dog alert. Is that correct?
It was a combination of both immigration and the canine alert, sir.
Okay. So you're saying part of the reason he was sent to secondary was immigration, not
Yes.
the dog alert?
Yes, sir.
But wasn't the decision made to send him to secondary, wasn't that decision made before he ever got to you?
Yes, sir.
And the decision was made, or you got the signal from Agent Spoonamore,
Correct.
before any immigration question was asked.
Correct.
And Agent Spoonamore gave you that signal because his dog alerted.
Correct.
So the dog decided to send him to secondary.
Correct.
How does the dog determine immigration status?
The canine does not determine citizenship, sir.
So he wasn't sent to secondary for immigration. He was sent to secondary because the dog alerted.
Mr. Anderson never answered my immigration question.
But the decision that he was going to secondary had already been made, correct?
Correct.
He could have pulled up to that primary checkpoint with a passport in his hand, and he was still going to secondary. Is that correct?
Correct.
Eventually, the corrupt cop attempted to shift the entire blame onto his canine, but the attorney quickly shut him down, making the judge's decision that much easier.
Is there any better documentation of U.S. citizenship than a U.S. passport?
No, sir.
So it didn't matter what he said, he was going to secondary.
Yes, sir.
Because the dog said so.
Because the canine alerted to his vehicle, sir.
Is a canine trained to alert to people here illegally?
No, sir.
So the dog wasn't alerting for immigration.
One Dave Fleischer side. Judges on and might come. And that's all for today. If you liked the video, subscribe so you don't miss out on the next upload. Thanks for watching.